Hello, and thank you for watching. My name is Bradford Roberts, Principal Broker, Founder, and Owner of TR Realty in the Las Vegas area. After watching this video, please be sure to like it as well as subscribe to our YouTube channel. Download the pertinent handouts for this video by clicking the link in the comments below. Now let's get started. This video is entitled Class 4 Seller Excellence. This segment is entitled Listing Agreements. All listing agreements must be in writing. Even though verbal listings are legal in the state of Nevada, they would constitute a violation of Las Vegas Realtor policy. So therefore, we only do written listings. If you're going to list a property that is owned by a trustee or a corporation, it is smart to get proof of authorization right now. You're going to need it anyway. So that way you have confidence that the person you're dealing with, the person who is signing our paperwork, is in fact the authorized person for the trust or the authorized person for the corporation. I'd like to talk about net listings. A net listing is a situation where a seller tells a real estate licensee how much he needs to net and therefore allows the licensee to list at any number above his net and take the balance as his commission. Net listings are legal in Nevada, however, they are a violation of LVR policy. So therefore, we do not do any net listings. You can probably surmise there's a propensity to enrich yourself unjustly with, a seller who may not be very sophisticated or up on current market conditions. So we don't do that. I'd like to talk about open listings as well. Also, open listings are legal in the state of Nevada, but a violation of LVR policy, so we don't do those. And an open listing is a situation where there is no exclusivity. In other words, any number of brokers can list the same property at the same time. And I'd like to talk about something known as a pocket listing. A pocket listing, as the name implies, is one that a real estate licensee procures from a seller and does not share it via the MLS. They keep it in their pocket. Now, the obvious reason to do that for the licensee is to attempt to double dip the transaction, to bring the buyer and therefore get both the buyer and the seller side commission. But as you well know, putting your commission, your personal interest ahead of the interest of your client is an ethical violation. So we do not do pocket listings either. Now, there are three types of listing agreements, actual contracts. One is the ER, which stands for exclusive right. One is the EA, which stands for exclusive agency. And one is referred to as the EU, which stands for exclusive right for unimproved property. Unimproved property, of course, is land and lots that have absolutely no house, structure, barn, garage, nothing on them whatsoever. So in the case of selling vacant land, we would use the unimproved listing agreement. We would not use the others. And the EA, the exclusive agency listing agreement, which would allow the seller to not only sell the property himself, but actually market the property by himself, even for a different price than he would list with us. We do not use the EA at TR Realty at all. We use only the ER form. So I want to share with you the concept of how to deal with what's known as an exclusion. So some agents will turn to the EA, the exclusive agency listing agreement, when there is some exclusion to the listing agreement. So let's say, as an example, you go out and you talk with the seller, and the seller says that his cousin, who happens to be out of town right now, loves his house and might consider buying it, and the seller would love the opportunity to sell to the cousin without recognizing or paying the real estate broker in the transaction. So some agents will then turn to the EA and use that form instead of using the ER. It's a bad strategy because not only is the cousin excluded, but then, as I mentioned a couple of minutes ago, the seller is able to go out and sell that property to anyone he wants. He's able to put it online, put a sign in his front yard. He can advertise at a different price, whatever he wants. So we don't do that. The correct way of dealing with an exclusion is to use that exclusive right listing agreement, the ER, and in additional terms, we will create a sentence. You come to me as your broker and I will create a sentence for you to exclude a particular individual rather than create this massive loophole by using an EA. So we only use the ER in this company. And for today's video, I have actually created a clause for you, a standard clause that you can use in this case. Please go ahead and get that clause library in front of you right now and follow along with me where it says compensation as per paragraph 5 of this agreement, we're referring to the listing agreement, shall not be due if the property is sold or leased by seller or lessee to, and then we would put in someone's name, during the above time period or any extension of said time period. Now, using this language, of course, we would have to choose sold or leased. We wouldn't put sold/leased. We wouldn't put seller/lessee. We would pick one of each of those two choices. But that could be the standard language that you use. And as you can see from the clause library, that would go into additional terms in the listing agreement. Another concept that I'd like to discuss with you before we get into the actual ER itself is known as absorption rate. Absorption rate. This is not something that I hear a lot of brokers talking about, but it's something that I want my team to be acquainted with, to calculate, and to use to their advantage. The absorption rate is the rate at which listings are absorbed into the marketplace. In other words, the rate that properties are selling. And I'm going to give a very, very simple way to calculate this. There may be some of you watching this video who think, wait, this is an oversimplification. There's a much better, much more accurate way to do these calculations. Yeah, absolutely. But if I make this too complicated, I know that most agents are not going to use it. So I want to give you a very, very simple way to calculate absorption rate. If you research a community, any given community, and let's say as an example, there are 10 listings available right now. Go back and look at how many listings sold in the last month. Let's just, for point of illustration, let's say that 5 listings sold in the last month. We would take the 5, divide by 10, and come up with an absorption rate of 50%. Let's go through that again. We look at the number of properties that are on the market today in a given community. That is our denominator of our equation. Then we look at how many properties in that community actually sold in the last 30 days. That would be our numerator, our top number in that equation. So back to my illustration, if there are 10 on the market right now and 5 sold in the last 30 days, 5 divided by 10 gives us a 50% absorption rate. Let's do another example to make sure you understand this. Let's say we look at another community and there are 20 properties on the market today. And then we go back and we ascertain how many properties sold in the last 30 days, and we realize that 15 properties sold in the last 30 days. 15 divided by 20 gives us a 75% absorption rate. And of course, a 75% absorption rate implies that there's more activity in that community than the first example I gave you, which had a 50% absorption rate. Let's take a look at one more example. Let's say we look at a third community, and there are 10 available listings in that community. And we look back at the last 30 days history, and we see that there have been 20 sales in that community. 20 divided by 10 gives us a 200% absorption rate. Okay? One more example to make sure you're with me on the math. Let's say we look at a fourth community, and we determine that there are 10 listings in that community as well. We go back and look at how many properties have sold in the last 30 days, and we find that only one property has sold in the last 30 days. 1 divided by 10 gives us a 10% absorption rate. Why is the absorption rate something that we should always calculate when we take a listing? Because the reality is that most agents just do a 6-month listing agreement or a 12-month listing agreement. They just do the same thing over and over and over again because that's how they always do it. That's not how we're successful in real estate. Let's go back to my fourth example, where one property sold in the last 30 days and there are 10 on the market, which, as we determined, would give us a 10% absorption rate. If you go out and you write a 6-month listing agreement, you have a 40% chance of failure from the day you write the listing agreement. Where am I getting this? So think about it. If one property sold last month and there are 10 on the market, there's a 10% absorption rate. Mathematically speaking, if one sold last month and things are continuing at their current pace, another one would sell this month, another one would sell the following month, one a month, right? It would take 10 months to absorb the listings that are on the market. Now, I know this is a simplification, as I said, but if properties are selling at the rate of 1 a month and there's 10, it's going to take 10 months to sell those properties in all probability. Why would you write a 6-month listing agreement? So, having gone through this explanation and these calculations with you, let me summarize this point by saying the term on the listing agreement should always match or exceed the absorption rate in the community. If you did not get that, please rewind this video, go back, go through the math, write it down, do what you need to do, but this is a very important point that I want you to understand. All right, folks, let's get the ER in front of us and let's start to dissect the listing agreement that we use here at TR Realty. It says at the top, exclusive authorization and right to sell, exchange, or lease brokerage listing agreement. And then in parentheses, it says ER. And right there in the title where it says lease should tell you that this is the listing agreement we also use for rentals. So for those of you who are property managers, or for those of you who are not property managers and you wish to do a courtesy listing, it's the same ER. In most states, the listing agreement for rentals is different, but in Nevada, we use the same one. So only one form to learn. Should be simpler for you. It says this is intended to be a legally binding contract. No representation is made as to the legal or tax consequences of this contract. If you desire legal or tax advice, consult your attorney or tax advisor. We are none of those things, right? Let's begin with paragraph 1, exclusive right to sell. It says, I or we, the seller. Well, let's stop right there. Who is the seller? The seller is anyone you find in the tax records, plus, if they have one, their spouse. So I want you to understand, even if a property is in the name of one person, if that person is legally married, the spouse can actually block the sale. There are rights that people have in the state of Nevada. Nevada is a community property state. I'm not going to get into legal matters here, but I have seen over the years cases where someone thinks they can sell their house without their spouse because their spouse is not on the deed and or not on the mortgage, but in fact the spouse does have rights regardless. So where it says I or we want to check the tax records, We want to include everyone's name who's in the tax records exactly as it appears in the tax records. And then we want to add any spouse or spouses if there are any. Line 3 says, hereby employs and grants TR Realty the exclusive and irrevocable right. What does that mean? Exclusive? Well, that's what the E stands for in this contract. They're hiring us to the exclusion of hiring any other broker. We are it. So this is a big deal. And then it says irrevocable. Irrevocable means it can't be taken back. So there would be no such thing as a unilateral right of cancellation in a listing agreement. It would take bilateral consent. Specifically in a listing agreement, it would require the seller and the broker to both agree to the cancellation for the cancellation to be effective. As I said, there's no unilateral right, hence the word irrevocable. Commencing on and expiring on. So here is our term. And how long should we put here? For those of you who've been paying attention, it should be a length of time that matches or exceeds the absorption rate in the community. To sell, lease, or exchange the real property located in the city of, county of. On line 7 is the APN, which stands for Assessor's Parcel Number. You get that out of the tax records, and we always have to have that in the listing agreement. And on line 8, that's where the full address of the property goes. We even want the zip code. If it's a condo, we want the unit number. So we have to have the full address and the assessor's parcel number in order to have a contract that I am comfortable signing. So please make sure you get both of those very important pieces of information in there. Paragraph 2 talks about the terms of sale. The listing price shall be X, and this is probably one of the very few blanks that you cannot pre-fill before you meet with a prospective seller, because we always want to pre-fill as much of our forms as we possibly can before we meet our customer. With a suggested amount of earnest money deposit of blank dollars. So it says with a suggested amount, because actually Nevada law is silent and does not require a buyer to post any fixed or set amount of earnest money. Now we can go into MLS and we can put some amount, but as it says here, it is suggested. And any buyer who writes an offer on that property is free to offer more earnest money, less earnest money, no earnest money, or whatever he chooses. Hence the word suggested. Now on line 11, where we fill in a suggested amount, my recommendation is somewhere around 1% of the property. That's pretty standard in this market. So if we were going to list a property for $200,000, we might do a suggested EMD of $2,000. But remember, it is just suggested. And then it goes on to say terms available. On line 13, we have some choices to make. Go slow here. Go cautious. Think these through one at a time. The first choice is cash. Is the seller willing to take cash? Now probably some of you watching this video say, well, duh, of course, every seller is willing to take cash. Not necessarily. There are some who would not want cash due to the ramifications of capital gains taxes. So although it's not very common, there might be a tiny percentage of people with whom you meet to sell their property who tell you, no, I do not want all cash in this transaction. The next choice is conventional. Is the seller willing to consider a conventional mortgage? Most sellers are. However, we know that when there's financing, then there's going to be an appraisal. And that appraisal process can be something that sellers sweat if they think their property is perhaps depreciating, or if they think that maybe their price is a bit high. They might concern themselves with the appraisal process, so they might be a bit reticent to accept conventional financing. And even more so with the third choice, which is FHA. Now, a couple things I want to bring your attention before you choose FHA. One is that FHA requires immediate occupancy by the buyer. So if there's a tenant in place who has a lease, FHA is not going to be a viable option. Also, another thing to know about FHA is that FHA requires the home to be habitable. So that can vary depending on the marketplace, but basically what that means is doors and windows have to lock, the hot water heater has to heat, the air conditioning has to get cold, there has to be kitchen cabinets in place, certain appliances have to be in place, there can't be any major issues with the property. So, keeping in mind the occupancy requirement and the condition requirement of FHA, your seller may or may not choose to accept FHA. And one more thing I want to share with you on the FHA choice is that most buyers who obtain FHA financing put a very low down payment, okay? And that's one of the reasons that FHA is attractive. So by putting a very low down payment, some sellers feel that without a lot of skin in the game, the cancellation rate for FHA deals might be a bit higher. The fourth choice here is lease. So this, from my opinion, this is a little bit out of order that they put lease between FHA and VA, but it's the association's form, not ours, so that's what it is. So if the seller is willing to lease, or if the seller is in fact not a seller at all but a lessor, then we could indicate lease. Then we come to VA. Now VA is very similar to FHA in terms of a strict appraisal, requiring the home to be habitable, etc. Very low down payment, in most cases $1. But there's something else that you need to know about VA that is different than FHA. And that is that in a VA transaction, there are seller mandated closing costs. Can't be negotiated away, can't be paid by the buyer, seller mandated closing costs. And in this market, in this day, it's typical in a VA transaction for a seller to incur somewhere around $1,500 worth of expenses. So in addition to the strict criteria of FHA for a seller, now we've also got a situation where the seller's going to have to pay some closing costs. One example of this, and we'll get into this more in my Class 5 video series, which is my contract class, but one example of this is a termite inspection. Termite inspection is absolutely required, regardless of the fact that we don't have a big termite problem in southern Nevada, and it is mandatory that the termite inspection is paid by the seller. So that's just one example. And then we come to a lease option. Lease option is a situation where we have two contracts that actually are contingent upon each other. And please tune in to my Class 8 video series, which is a rental class. I will do a segment on lease options there as well. But we have two contracts. We have a lease, just like any other lease, and then we have an option to buy. The next choice on line 14 is owner will carry. You'll see this abbreviated in real estate as OWC. This is another way of saying seller financing. A lot of agents confuse lease option with owner will carry. In a lease option situation, the buyer, if you will, is not getting possession of the property. They're not taking legal ownership of the property. They are leasing until such time as they choose to exercise their option to purchase. However, in an owner will carry situation, we actually have a conveyance of the deed right now. It's a situation where the seller of the property is acting as the bank. They could do that in first position as a first mortgage or in second position, but it's a situation where the deed does convey, and now the buyer of that property, the new owner of that property, is making payments to that former owner of the property. And then there's a spot for other. There are other types of financing. There's hard money financing, there's USDA financing, and there's some others. On line 15, it says, if the property is offered for lease, then the term seller in this agreement includes landlord as applicable. I would much prefer the word lessor, but nonetheless, this is the word that the association has chosen to put on this line. So that will allow us to use this ER in a rental situation. On line 18, we have a choice to make. It says seller does or does not authorize broker to disclose the existence of multiple offers to potential buyers. And my opinion here is that we should attempt, if our seller agrees, to do does. And the reason that I like does instead of does not is because my experience tells me that most agents are going to somehow disclose that information anyway. Whether it's direct or indirect, maybe inadvertently they will disclose whether there's other offers on the property. If it says here, does not, and we actually let another agent know that there are other offers on the property, we have breached the listing agreement and we've committed an ethical violation as well, and we don't want that to happen. So we should err on the side of does. And on line 19, you see that the sellers would need to initial this paragraph. Just as a reminder, anytime you see a paragraph or a provision in a contract that requires separate initials, should the party or parties not initial that entire paragraph or provision would not apply. Let us move on. Paragraph 3 on line 21, it says property offered for sale. The listing price noted above includes the property and all improvements and fixtures permanently affixed and installed. The following items of personal property are included, and then on line 28, the following items of personal property are excluded. In real estate, there can be disagreement over what is real property and what is personal property. There are some things, in my opinion, that are just not that clear. Let's go through this a little bit so you understand what I want in paragraph 3. Let's say somebody bought a house that did not have any ceiling fans, and 6 months later they decide to install some ceiling fans. So they go to their local home improvement store and they buy 2 ceiling fans. They install one of them in the living room. It is mounted to the ceiling, it is installed. But they run out of time and they don't have the opportunity to install the one that goes in the bedroom. So they leave that one sitting in a box in the garage. Well, you know, people get lazy, people don't have a lot of time, so the time comes that this person wants to sell the house. How many ceiling fans do you think the buyer would expect to convey? 2, 1, or 0? Well, I've heard the argument of 2 because the seller intended to install 2 ceiling fans. I've heard the argument of none because it was the seller who installed them. Those ceiling fans were not attached, not included when he bought the property. Both of those arguments don't fly. The answer is 1. Why would the buyer expect 1 ceiling fan? Because it was only 1 ceiling fan that was permanently attached and affixed to the real property. And we should know that any property attached to real property also becomes real property itself. So to conclude my little illustration there, the 1 ceiling fan that was attached is something the buyer would expect to get. The other ceiling fan that's still sitting in a box in the garage, the seller is free to take that unless it is otherwise addressed in the contract. And to stave off disagreements or at least disappointments, I think paragraph 3 should be used wisely. I would not use paragraph 3 as an excuse to get into laborious discussions of what constitutes real property, what constitutes personal property. I would probably err on the side of disclosure here and say very clearly, even though you think the reasonable average person would probably know this is real or personal, I would get it in here very clearly. We did have a situation several years ago
where one of our agents here at TR Realty was listing a very expensive property, and there were these incredibly beautiful, expensive mirrors on the walls. There were 10 of them, if I remember correctly, throughout this very elaborate multi-million-dollar home. And when the buyer came to do the walkthrough, the mirrors were gone. And the buyer was really, really upset about that because these mirrors were gorgeous. They were custom-made mirrors. So the buyer's agent said, hey, the mirrors should be here. They're attached to the wall. Why aren't the mirrors here? And the listing agent, my agent, said, no, they were not attached at all. They were hanging like pictures. I don't know what any given judge would say on any given day. I think there's a reasonable expectation that mirrors are probably attached to the wall. But in this particular case, turns out they were not. They were hanging like pictures. Therefore, the seller felt that those were personal property and he could remove those from the real estate. Long story short, at this point, these mirrors turned out to cost $18,000 each. And I believe there were 10 of them. To make this transaction close, the seller ended up writing a $50,000 check to the buyer at close of escrow because those mirrors had been removed. Now, you don't want a client coming back after you looking to rectify that situation, right? So that's why it's very important that we delineate very, very carefully in here what's going to stay and what's going to be removed from the property. Line 32 goes on, seller intends that the above items be excluded or included in offering property for sale. So what we put here is also what we need to put in MLS. Seller understands that the purchase agreement takes precedent over any intention identified above and will ultimately determine what items are included and excluded in the sale, and that the broker is not responsible for and does not guarantee that the above items will be in the purchase agreement. Moving on to 3C, leased or liened items. The following items are leased or subject to a lien in securing payment. And this is where we would indicate the solar power system, alarm system, propane tank, water softener, or other features of the home that sometimes people lease or sometimes people finance. We did cover that in an earlier video segment here in Class 3. These things need to be disclosed and dealt with. Line 41 says, seller will provide to buyer as a part of the purchase agreement copies of lease documents or other documents obligating seller to pay for such leased or liened items. Moving on to page 2 of the ER, paragraph 4 talks about title insurance, that the seller is agreeing to provide the buyer with an owner's policy of title insurance in the amount of the selling price. We're going to get into that in more detail in my video series Class 5, my contract class. This title policy that we're talking about here in paragraph 4, usually called owner's policy, sometimes called a seller's policy, and despite the name, it actually protects the incoming buyer on the property. Paragraph 5, compensation to broker. Folks, you got to get this one right. This is your paycheck. Compensation is solely a matter of negotiation between broker and seller and is not fixed, suggested, controlled, or recommended by, it says here GLVAR, but they have recently changed their name to LVR, MLS, or any other person not a party to this agreement. Seller agrees to pay broker as compensation for services. On line 8, if a sale, some percentage of the gross selling price of the property. My recommendation here is 6. It is a recommendation. Commissions are not fixed, and broker consent is not required on commission at TR Realty. So if you want to charge 5 or 7 or 4 or 12, it is totally your decision to do that. But what you put on line 8 is the total commission for both sides. Okay? So as an example, if we are going to take 3% on our listing side and offer another 3% to the broker who brings the buyer, then line 8 is going to say 6%. And then it says, and or some flat fee amount. Folks, that is our processing fee. Now, if you watched my video series, Class 1, I did a segment on processing fees. You know that TR Realty is going to charge $299. However, we give our associates the flexibility to put what you wish here, either more or less. And if it's more, it's going to be added to the commission that the associate receives. If it's less, it would be deducted from the commission that the associate receives. But my recommendation here is $299. And it goes on to say that seller agrees that broker will offer some percentage or dollar amount to the cooperating broker who is the procuring cause of the sale. There's that term, procuring cause, that we talked about in Class 3. Seller acknowledges that offers of cooperative compensation are between brokers and are not negotiable between seller and buyer. And then it goes to the lease section. If we are taking a listing for a rental property, we are paying some percentage of the rental or a flat fee amount. It is common in Southern Nevada to do a flat fee amount for a rental listing, which of course is referred to as a courtesy listing if you're not a property manager. It's common to take somewhere between $600 and $1,000 and then to go ahead and divide that with the cooperating broker on line 4. Line 18 says compensation shall be due, A, if the property is sold or leased by broker or through any other person, including seller, on the above terms or any other price and terms acceptable to seller during the above time period or any extension of said time period. So very important words there on line 20, including seller, meaning that once a seller signs his listing agreement, we are going to get paid, okay? We are entitled to be paid. And the seller, even if he advertises the property or sells it to a relative or a friend or whatever, our commission is still going to be due. Paragraph 5B, if the property is transferred, conveyed, leased, rented, or made unmarketable by a voluntary act of seller without the consent of broker during the time period or any extension of said time period. Paragraph 5C says, if within some calendar days of the final termination, including extensions of this agreement, the property is sold, conveyed, or otherwise transferred to anyone with whom the broker has had negotiations or to whom the property was shown prior to the final termination. This is our protection period. And by putting a number of days in here, it actually takes the length of the listing agreement and any extensions of the listing agreement, and then further extends that time period to cover anyone who saw the property or any negotiations that there were on the property during that term. And my recommendation here on line 25 is to put 180 days. Paragraph 5D says, in the event of an exchange, permission is hereby given to the broker to represent such parties as broker may deem appropriate and collect compensation from them, provided that there is full disclosure to all parties. If completion of sale is prevented by default of seller or the refusal of seller to accept an offer in accordance with the price and terms of this agreement, then upon event, broker is authorized to take any action reasonably necessary to collect said commission. So what that means is, if we have a listing agreement with a seller and the seller tells us these are the terms I'm willing to accept, this is the price I'm willing to accept, and we bring in an offer that satisfies those criteria, our commission is then due. And paragraph 5E says broker is authorized to cooperate and divide with other brokers the above compensation in any manner acceptable to broker. So we talked about that earlier in this video series. We talked about how it's not an automatic requirement that, let's say, a 6% commission is divided 3 and 3. It can go different ways. And that is up to our discretion, although it does require the consent of the seller, and signature of that commission division would constitute his consent at that point. This paragraph 5E goes on to say, in the event any sum of money due under this agreement remains unpaid for a period of 30 days, Such sum shall bear interest at the rate of some percent. My recommendation here is 10. Let's take a look at paragraph 6. It says, broker is authorized to accept on seller's behalf a deposit to be applied toward purchase price or lease. Said deposit shall be held by, and then we have to make a choice. If this listing agreement is used for a sale, we're going to choose escrow. If this listing agreement is for a courtesy listing, we're going to say owner. We're going to check the box that says other and write in the word owner. In no case does the broker hold the earnest money deposit, or in a rental situation, we would refer to this as a holding deposit. Moving on to paragraph 7, agency relationship. Broker warrants that he holds a current valid Nevada real estate license. Broker shall act as the agent of the seller and may also assign or designate a licensee of the broker who shall act as representative of the seller in any resulting transaction. 7b, depending on the circumstances, it may be necessary or appropriate for the designated licensee to act as agent for both seller and buyer, exchange parties, or one or more additional parties. If applicable, broker and the designated licensee shall disclose to seller any election to act as an agent. And then it says on line 4, obtain the written consent to act form. The consent to act form is something that we've already covered here in the Class 4 video series. Absolutely mandatory if a real estate licensee in the state of Nevada is potentially representing both sides in a transaction. So seller and buyer, lessor and lessee, we absolutely have that consent to act form. It is a must. It's a big deal. All right, let's move on to paragraph 8, required disclosures. 8A, unless exempt under NRS Chapter 113, seller shall truthfully complete and sign a seller's real property disclosure statement concerning the condition of the property. Seller shall update the seller's real property disclosure as necessary. 8B, if the property is or has been the subject of a construction defect claim, whether litigated or not, seller shall provide the disclosure as required by Nevada law. 8C, if the property was built prior to 1978, meaning 1977 or before, seller shall complete the disclosure of information on lead-based paint hazards in accordance with federal regulations, and we have talked about that in my Class 4 video series as well. 8D says, seller acknowledges receipt of the residential disclosure guide, and you see there on line 18 that we require the seller to initial off on that. And that's why earlier in this video series, when I gave you a list of documents that you should be getting from the seller at the time of taking the listing, one of the forms on my list was that RDG, that Residential Disclosure Guide. And that's because here in the listing agreement itself, the seller is already acknowledging receipt of it. So this is not something that we can go back and get later. We need to get it now and get this initialed on line 18. All right, let's take a look at paragraph number 9, which is indemnification. Seller agrees to save, defend, and hold broker. It says here GLVAR, but it's now LVR, and that change will be made the next time they update the listing agreement. And the MLS harmless from any claims, disputes, litigation, and or judgments arising from any misrepresentation, breach of warranty, breach of a promise by seller, any correct information, any facts concerning the property not disclosed by seller, etc. Let's go to line 25 where it says this indemnification shall survive broker's performance in any transfer of title. So that indemnification provision not only protects us during the term of the listing, but will go on to protect us in perpetuity afterwards. Paragraph 10 talks about fair housing. I think if you've watched my videos for any amount of time, or if you know me personally, you know that I am a staunch advocate for fair housing, for treating everyone equally and fairly. And certainly here at TR Realty, I will not tolerate one iota of discrimination. I will not tolerate any breach of fair housing whatsoever. So this paragraph says that broker shall offer the property for sale or lease without regard to race, color, religion, sex, national origin, age, gender identity or expression, familial status, sexual orientation, ancestry, or handicap, or any other current requirements of federal or state fair housing laws. That is clear and obvious. Paragraph 11 talks about common interest communities. The property is or is not located within a CIC. And when we use the term common interest community, it is an umbrella term that takes into account homeowners associations, condo associations, and cooperative associations as well. So a choice needs to be made here on line 32. And following the line 32 and 33, you'll see a section starting on line 35 that seems to repeat 3 times. It looks like the typewriter got stuck, right? But actually, the reason that the section repeats 3 times is because it's possible someone could own a property that is subject to the rules and regulations of 3 separate common interest communities. In fact, if you live in Summerlin or if you live in Green Valley, you automatically have at least 2 common interest communities with rules and regulations for your community, and in some cases there is a third as well. So that's why there are 3 separate sections here for the seller to indicate the name of the community, the contact telephone number, how much the dues are, whether they are monthly or quarterly. In some cases there's even annual dues, etc. And on line 45 it says if the property is located within a CIC, seller acknowledges and agrees to obtain at seller's own expense as required by Nevada law, and or provide the information required by Nevada law to broker for delivery. This is the resale package or resale packages that the buyer must obtain as per Nevada law. And you see it says here on line 45, at seller's own expense. So not paid by the agent, not paid by the buyer, not reimbursable. This is a seller mandated expense now as per Nevada law. Moving on to paragraph 12, this talks about special assessments. Special assessments typically come in 2 forms. One is known as a SID, the other as a LID. So SID stands for Special Improvement District. LID stands for Limited Improvement District. Some people say local improvement. It's not local, it's limited. Nonetheless, SIDs and LIDs can be imposed by a builder. They could be imposed by an association. They could even be imposed by a municipality, such as a city or a county. And on line 49, the seller needs to indicate if the property is subject to any of those assessments, SIDs or LIDs. And as a real estate professional, if you want to do a good, thorough job, you will notice the website on line 50, and you will go to that website and verify for yourself because you could be responsible for misinformation. And if there are any outstanding assessments, SIDs or LIDs, at the top of page 4, lines 3 through 5, that's where you're going to indicate any outstanding balances, when payments are due, how they're payable, etc. All right, let us take a look at paragraph 13, which is entitled Keybox. But in the real estate business, we typically refer to this as a lockbox. It is the same thing, by the way. Line 7 says, seller does or does not authorize broker to install a keybox in connection with the showing of the property. So there's a couple of things we have to choose there in that sentence. Seller does or does not. Of course, we always prefer to put a lockbox on a property. Putting a lockbox on a property increases the number of showings. It's that simple. When a buyer's agent has to make an appointment with the agent or make an appointment with the seller or call, there's going to be fewer showings. So lockbox is always the way to go if the seller is on board with that. And then we have to choose electronic or mechanical. Well, at TR Realty, the choice is simple because we do not use mechanical lockboxes. Mechanical lockboxes don't have the capability of tracking who goes into the property, when they go in, their name, their license number. When you use an electronic lockbox, which we are now using electronic lockboxes called Sentry boxes, they record all of that information. So there's a lot more protection for the homeowner, a lot less liability for us, as opposed to a mechanical lockbox where anyone can give the combination to anyone, and then we have no idea who's going in and out of that property. So no mechanical lockboxes at TR Realty, no mechanical lockboxes at TR Realty. Got it? It goes on to say, a mechanical lockbox is a combination type box that can be opened by anyone who has access. That's what we just talked about. The MLS requires that a valid working code for a mechanical lockbox be included. We're not going to do that, okay? So let us move on to 13A. I'm on line 13 now. It says the purpose and function of the key box is to permit access to the interior of the property by all members of MLS, as well as any licensed professionals necessary to facilitate the sale of the property. B, seller should safeguard personal property and valuables. C, it is not a requirement to allow the use of a key box. D, where a tenant occupies the property, this is important, the tenant's consent is also required, which shall be obtained by the seller or his or her property manager. So I want to be clear we understand that. If there's a tenant in a property, and we're going to list that property for sale, and the owner wants a lockbox, not only must the owner consent, but the tenant must consent as well, okay? I want to be very clear. If you're going to list a property that's tenant occupied, you need the tenant's consent and the owner's consent, both of them, before you can put that lockbox on the property. And paragraph 13E, seller does or does not authorize broker to use one-day codes to access the electronic key box installed on the property. A one-day code is an electronic means to allow access to the key box key compartment. Broker shall only issue such codes to licensed professionals. Broker further agrees to use all reasonable means to verify the identity of said licensed professionals. What they're talking about here is these Sentry boxes, which are the newest generation of lock boxes that we are using, they actually have a keypad on the surface, on the face of the lockbox. This is the first electronic lockbox we've ever had that actually allowed us to put in a code rather than just use our Realtor provided means of access. So now we don't need a mechanical lockbox for someone like a cleaning service, as an example, or a handyman who might be doing work on the property. We can just use the electronic lockbox and we can issue a one-day code to that person. So it is up to your seller to decide whether they're willing to allow those one-day codes. But I want to be very clear. Never, ever give out a one-day code to anyone unless the seller has consented here in paragraph 13E. Another use for the one-day code, by the way, could be an agent who's non-MLS, such as an agent whose license is with TR Alliance, as an example. And 13F says owner acknowledges that GLVAR, well, LVR now, MLS broker or its listing agent is not insuring owner or occupant against theft. You see that typo, insuring? It should say ensuring, but we don't mess with the association's forms. So we are not insuring owner or occupant against theft, loss, or vandalism resulting from such access. Owner is responsible for taking such steps as may be necessary to secure and protect the property during any time that a key box is being used and obtaining appropriate insurance. So that's an important paragraph. There's a lot there in paragraph 13. But if you're going to use lock boxes, as you know, we always strive to do, then we've got to get the right consent. We've got to get this paragraph done correctly. So if I didn't say something clear in that paragraph, please go ahead, rewind the video, and hear it again. Paragraph 13 is quite important. Moving on to paragraph 14, it says the property is or is not currently occupied by a tenant. It's not asking if the property is occupied. It's asking if it's occupied by a tenant. And there's a couple of reasons for that, right? Number one is that lockbox authorization form that I just mentioned. Another reason is because we're going to need to know who's in the house. We're going to need to make arrangements to view the property. knowing that there's a tenant in the property, possibly animals in the property as well. We got to be careful of that. And there's one more thing I want to mention here, where it goes on to say the property is or is not subject to a management agreement. And if there is, we fill in the information about the management company and contact information. Why is this a big one? Well, the thing that comes to mind for me, first and foremost here, is the fact that some property management companies who create their own forms, okay, this is not standard LVR paperwork like we use at TR Realty, but some companies will create their own forms. There are forms out there that say, if the owner wishes to sell the property while it's during the term of the management agreement, that the property management company automatically becomes the listing broker to that property. This is not something that you would think about. It's not something that you would see. Chances are when you're listing a property, if there's a management company, you still don't get to see that property management agreement. But I want you to be cognizant of that. And if I were listing a property and I found out that a management company was in place, I would probably request a copy of that management agreement, or at a minimum, ask the seller to read it very, very carefully, just in case there's language making that other broker the automatic listing broker. I don't want to have a claim about tortious interference. In other words, interfering with someone else's legally binding contract. Paragraph 15 talks about FIRPTA. If you're not familiar with FIRPTA, it stands for Foreign Investment in Real Property Tax Act, FIRPTA, pronounced in our industry as FIRPTA. And FIRPTA recently changed from a 10% withholding to a 15% withholding. That sounds like a 50% increase to me. And FIRPTA is federal law. It comes from IRS code, which is designed so that someone can't sell a piece of property, make a profit, take those profits offshore, and not pay their share of taxes in the United States. So here in paragraph 15, specifically on lines 45 through 47, the seller needs to disclose if he is subject to FIRPTA or not. As a real estate licensee, you cannot make the determination. This is harder than you think. There are people who have trusts and LLCs. There are situations where one spouse has one legal status, the other spouse has different legal status. If there's any question about FIRPTA, the seller needs to contact the title company and ask if they're going to be subject to the FIRPTA withholding or not. Again, this is not a determination that we as real estate professionals can make. Paragraph 16 talks about mediation. If you're not familiar with the concept of mediation, it's a process where a neutral third party will listen to the parties to the contract and come up with what that person feels is a viable resolution to the dispute that they're having. So the difference between mediation and arbitration is that in arbitration, it's a binding decision. So when that neutral third party makes a determination, this is what they think is fair, the parties are obligated to adhere to it. Mediation is not binding. So what happens is the parties get together with that neutral third party, they present their case, if you will, and that mediator will say, this is what I think is fair and reasonable, this is what I think you can do. However, the parties are not obligated to follow that. But this provision of our listing agreement does say that the parties will agree to mediate before they litigate. And of course, mediation is always faster, cheaper, easier, less nerve-wracking than going to court, than filing a lawsuit, right? So we're all about mediation. And in this paragraph, I want to point out the fact that it talks about mediation at the Realtor Association. And just so you know, the Realtor Association announced they will be getting out of the mediation business. So in the subsequent version of the ER listing agreement that will be coming out sometime this year, we think, it will no longer say LVR mediation. we will be required to go to an outside source for mediation. And on page 5, page 5, line 5, it says seller's initials and broker initials. If the seller initials, I will always initial this because I am a proponent of mediation. Try to encourage your seller to do this. We don't want to just, run to a courtroom, okay? We want to try to mediate our differences here in the family, right? So let's try to get initials on line 5. Paragraph 17 gives us the right to put the property into the multiple listing service. Paragraph 18 gives us the right to market and advertise the property. I want to bring your attention specifically to line 17 in that paragraph, where it says seller agrees that the property may be advertised in any and all formats of media, including but not limited to electronic and print advertising. So paragraph 18 gives the real estate broker, the listing broker, a lot of flexibility in how they can market and advertise the property. That brings up some very, very recent changes to this listing agreement. This has just recently changed, and our compliance department is seeing all kinds of questions and confusion about this. So I want to slow down here for a minute and make sure that everyone watching this video can understand exactly what's going on here. It says on line 29, seller does or does not authorize broker to commence public marketing and advertising activities. If the seller wants the property in MLS, if the seller will allow a sign, if the seller will allow us to put the property on our social media, on our website, Realtor.com, Zillow, Truly, etc., they have to indicate does. If the seller indicates on line 29 does not, then as the listing broker and agent in the transaction, we can't do anything. Understand that is tantamount to a pocket listing. No MLS, no sign, no open house, nothing, nothing, nothing. Just a pocket listing. So that, in my opinion, is almost never to the advantage of the seller. Therefore, on line 29, I really want to see in every case does. The seller does authorize us to commence our public marketing. And then, very closely related to this, if you look at the new paragraph 19, seller does or does not authorize broker to install a for sale or for lease sign on the property. Seller may only authorize a sign if seller has authorized marketing and advertising in section 18. Think about that. So my compliance department is seeing cases where on line 30, sellers are initialing that the seller does not authorize public marketing, but then on line 32, they do allow a sign. Nope, doesn't work that way. A sign is public marketing. So the vast majority of the time, we want the seller to choose does on line 29, the seller to choose does on line 32, and that will allow us to put a sign. Let's go to paragraph 20. Seller further understands and acknowledges that MLS will disseminate the property's listing information to those MLS brokers and agents or their web vendors who operate internet sites, as well as other online providers, etc. This paragraph is known as an opt-out paragraph. And if you drop your attention down to line 48, it says, I've advised the broker I do not want a commentary section displayed. Well, certain websites, real estate websites specifically, have commentary sections, almost Yelp style, where anyone can go on and they could write a little bit of a review. Hey, I saw this house. It's crawling with rats and scorpions. You shouldn't see this house. It's terrible. It's where someone can go online and air a grievance that maybe doesn't even exist. So we hope that our sellers do not choose that option because, in my opinion, even though it's possible that someone could write something negative, there's a lot of good potential there to have that. So we don't want to opt out of A if we can help it. B, I've advised the broker I don't want an automated estimate of value. Well, as you might know, there are certain websites that will use comps and some complicated algorithms to come up with a value of a property, somewhere across the country and in their software or whatever. This can be sometimes not that accurate, but I think that by not having the value displayed, it does arouse some suspicion in the minds of people who are looking on these websites. So we're also hoping that the seller doesn't choose this. What we want as real estate professionals is the seller to initial line 11, where it says seller does not opt out of any of the above. And again, that's going to give us more exposure, more opportunities for marketing and advertising, which ultimately is better for the seller anyway. Paragraph 21 is not only very important, but it's actually a brand new paragraph. So I'm going to go a bit slower through this paragraph to make sure that we understand it completely. This is, again, something that is causing a lot of aggravation with compliance as agents don't understand this paragraph. Let's go through it together. Paragraph 21 is known as the office exclusive. Seller does not authorize broker to disseminate listing information about the property via MLS. However, seller acknowledges and agrees that broker will file the fully executed office exclusive form with MLS in accordance with MLS rules and regulations. Further, seller acknowledges and agrees that if there is any public marketing of an office exclusive listing, then broker must submit the listing to MLS for dissemination to its participants within 1 business day of public marketing. Public marketing includes, but is not limited to, flyers displayed in windows, yard signs, digital marketing on public-facing, multi-brokerage listing sharing networks, and applications available to the general public. Seller does or does not select an office exclusive listing. Seller may not select this option if seller has authorized marketing and advertising in Section 18. What we want here is does not. We want does not. The seller does not select an office exclusive listing. And obviously this cannot conflict with the paragraphs above that could end up giving us a pocket listing. You cannot keep the property off the market and then display it in MLS, or conversely, you can't put it in MLS and then say the seller does not want the property to be advertised. So our preferred choice here is does not. And if you submit a listing agreement for my signature that says seller does select office exclusive, the property cannot go in MLS, on social media, on a website. You can't put a sign. You can't do anything. And I know this is a little confusing, but this is the National Association of Realtors' new clear cooperation policy. Folks, what was happening here is that some agents were taking advantage of a relatively new feature in MLS called Coming Soon. Agents were putting the property in MLS into Coming Soon status. And what that means is if it's coming soon, it can't be shown right now. And then the listing agent was turning around, doing an open house, putting a sign, talking to buyers, and advertising and promoting the property in an attempt to bring the buyer by himself, to double dip the commission. Well, obviously that is not in the seller's best interest, and it is also a clear violation of the pledge of what it means to be a realtor. What it means to be a realtor is to share with other realtors. I mean, after all, that's what MLS is all about. So, understand that if you choose in here, seller does select an office exclusive listing, that is a pocket listing, and you can do absolutely nothing to promote that property. Bad for the seller, and that's why we don't want it. Paragraph 22 talks about the use of the listing content. This paragraph basically says that the broker owns and controls anything that we do, such as flyers, such as photographs, any other kinds of videos, virtual tours, drawings, that kind of thing. Paragraph 23, Nevada law, The concept here is that this contract was prepared for a Nevada property, therefore Nevada law is going to govern any disputes. Paragraph 24, all prior negotiations and agreements between the parties are incorporated into this agreement. So this is the entire agreement that exists between the seller and the broker. There are no outside agreements or other verbal agreements. And very importantly, I want to bring your attention down to line 49, where it says in bold print, the parties agree that an MLS change order signed by broker and seller shall act as a valid written addendum to this agreement. Read that sentence again and read it carefully. An MLS change order signed by broker and seller, if it's not signed by the broker, it's not a valid change order, shall act as a valid written addendum to this agreement. Now, we're going to be talking a little bit later in this Class 4 video series about the MLS change order, how we use it correctly. But here in the listing agreement, the parties are agreeing that the change order is going to be an addendum to the ER. Paragraph 25, partial invalidity. Basically, if one provision of this agreement is deemed invalid by a court, it doesn't invalidate the entire agreement. Paragraph 26, the prevailing party is entitled to court costs and reasonable attorney fees in the event of litigation. 27, I'm sorry, I have to chuckle. Paragraph 27 is a little bit interesting to me. It's a relatively new paragraph as well that was created by counsel for the association. I don't know how enforceable this is, but I haven't graduated law school, so maybe I don't know. But paragraph 27 is a damages cap paragraph that is an attempt to limit our liability to the amount of the commission that was collected. And very specifically, I want to bring your attention to the middle of line 15, where it says, the maximum aggregate, that means total, liability of broker to seller under this agreement shall not exceed the aggregate commission amount that has been paid by seller to broker. So again, I'm not a lawyer, but I would interpret that to mean if the seller hasn't paid us any commission, then we don't have any liability. I'm not really sure about that. I predict at some point this paragraph is going to go bye-bye. We'll see. Paragraph 28 talks about warranty of ownership. Seller warrants that he is the sole owner of the property and he has the authority to sign this agreement. 29 is a paragraph about foreclosure in which the seller needs to disclose to us if either a notice of default or a summons and complaint has been filed on the property. You might know that a notice of default is an intent by a lien holder to file a non-judicial foreclosure, and the summons and complaint is an intent by a lien holder to file a judicial foreclosure. And Nevada is a non-judicial foreclosure state, meaning that the lien holder has the right to go either way with the foreclosure action. Paragraph 30, this agreement may be signed by the parties manually or electronically and on more than one copy, which when taken together, each signed copy shall be read as one complete form. That's interesting. So let's say we have the seller of a property sign a piece of paper, this ER, and for some reason it gets maybe transmitted to me by fax, and I decide to sign that fax copy. That's not the copy that the seller signed. And Nevada law, and as per the language in this contract, says that as long as the two copies are identical, so truly identical, no differences of any kind, we don't need the signatures on the exact same piece of paper. One party can sign one copy, the other party can sign the other copy. As long as they're truly identical, when taken together, we do have one legally binding contract. Paragraph 31 talks about recommendations. If broker recommends a builder, contractor, escrow company, title company, etc., we are not liable for that. 32 is an important paragraph. I want to go slow in this one. If seller materially breaches this listing, seller is in default, and will be liable to broker for the amount of the broker's fee specified in Section 5 and any other fees broker is entitled to receive under this agreement. Did you get that? If the seller breaches any provision of this listing agreement, we are entitled to collect our commission. Seller default. Paragraph 33. This is interesting. It says in paragraph 33 that this agreement and the obligation to pay our commission is binding upon the seller and the seller's heirs. So even death does not get a seller out of paying our commission. 34 is also important. Talks about joint and several liability. In case you're not familiar with the concept of joint and several liability, it means that all sellers who are signing this agreement are equally responsible for the full value of the agreement. So let's say, as an example, we have Tom and Judy Smith sign a listing agreement. Tom and Judy Smith owe us our commission. Let's just say it's $10,000. It's not a situation where Tom owes us $5,000 and Judy owes us $5,000. Tom and Judy are both equally responsible for the full payment of that $10,000 commission. So that is my layman's explanation of what joint and several liability is for our purposes. Paragraph 35, it's a short one, but it's a big one. And paragraph 35 talks about the concept, time is of the essence. This is something that is also in my Class 5 video series when we do the contract, because that language also appears in the purchase and sale agreement. Time is of the essence is a phrase that a lot of people think means hurry up. That's not what time is of the essence means at all. It doesn't mean hurry up. What it means is that the dates and the deadlines in the contract must be respected. Or actually, I like to use the word sacrosanct. Sacrosanct, if you're not familiar with that word, means respected exponentially, revered. So when we use the phrase time is of the essence, it should tell us how important it is to respect the dates and the deadlines in that particular contract. They're not suggestions. They're hard obligations. And if the parties do not perform whatever date and deadline obligation they have by that date or deadline, they are in default. And again, I'm not an attorney here, but there are severe legal ramifications for allowing your party to go into default, whether it's on a listing agreement, buyer brokerage agreement, purchase and sale agreement, or any other contract that they sign. Time is of the essence means the dates and deadlines must be honored. Paragraph 36, the seller does or does not intend to perform an IRC Section 1031 tax-deferred exchange. So I can't give tax advice. You already know I'm not an attorney. I'm also not a CPA or an EA. So that stands for enrolled agent, by the way, in case you didn't know. I know we also use EA, meaning exclusive agency in real estate. But I'm not qualified to give legal or tax advice. My understanding here is that the 1031 exchange was named after the IRC, which stands for Internal Revenue Code, part of the Internal Revenue Service, IRC 1031, that allows a participant in a real estate transaction to defer the payment of capital gains tax. So again, I'm not qualified to talk specifics in this area, but if one of the parties would like to take their profits and roll those over to a like-kind property within a short and designated period of time, they are deferring or delaying the obligation to pay capital gains taxes on those profits. So the parties do have the right to engage in a 1031 exchange. That right is enshrined here in paragraph 36. And if you ever have a customer who's considering a 1031 exchange, make sure they talk to an attorney or an accountant who is capable of discussing the details and guiding them. We certainly cannot get involved in that. I'd like to bring your attention now to the most dangerous paragraph in the entire listing agreement. And that is the paragraph that begins on line 21 and ends on line 24. That is blank space that way too many real estate agents feel compelled to fill with crap. Folks, the number one thing that real estate agents do to get themselves in trouble is to create language. Let me be clear. Never, never write language. You are practicing law without a license if you do so. Not to mention, if you don't get the language right, you can really hurt the parties in the transaction and create havoc for everyone. So, this is why we have a clause library. And if there's a particular situation that my clause library does not address, that's the time you go to your broker. Contact me and let me deal with the scenario. 9 times out of 10, an agent comes to me for language with something, it's because they haven't read the contract. They think they need to add something when in fact it's already addressed in the contract. So 9 times out of 10, I tell my agents, you don't need any language. Folks, let me say it again. Never, never write language. If you want to be smart, you will fill in the blanks of this agreement or any other the way I'm teaching you to do so. You will not cross out, you will not add, you will not amend or write anything in the agreement. Keep it simple, keep it clean. Let's drop down to line 31. By signing below, seller consents to receive transmissions sent from broker to the email address set forth. Seller agrees to keep broker advised of his address and telephone number, etc. From lines 36 to 40, all of that must be filled in. And of course, there's initials down the bottom of this page and every other page as well that have to be initialed. If you submit it to us for my signature and it's not initialed, we're going to kick it back to you. All of this needs to be filled in. We need a valid address for the seller, which may or may not be the address of the property. We need an email address, we need a telephone number, etc. Very important that you follow the correct order of signing. Seller signs first. Designated licensee, that's you, signs second. Broker signs last. I cannot sign a listing agreement, or any other agreement for that matter, that has not been signed first by the client, second by the designated agent. Okay? So when you send it to compliance, you need to make sure the seller signed it, you signed it, and then I sign it last. Let's move on to page 9 of this ER. This is the brokers section. On line 2, you would write in TR Realty, and you would put the address of the office where your license is. Other information such as telephone, fax, and email can be your information. Designated licensee signature on line 5, license number also. We have to have the license number. Then the broker, as I mentioned, will sign it last on line 7. And I want to bring your attention to line 10, bold print, capital letters. An exclusive brokerage agreement must be signed by the broker to be valid. I want to be very clear. If you put a listing into MLS without a valid listing agreement, I will cut your head off, okay? You cannot do it. It is a monster violation. It brings up insurance liability issues, all kinds of problems. We have to have a valid listing agreement, which means signed by the seller and signed by me for you to put in an MLS or do anything with the property. Let me say it again. Never, never can you promote a property. Never can you put a property in MLS without a valid listing agreement signed by the broker. I hope that's clear. And moving on to page 10, I don't want you to forget this page. I know this is easy to forget because there's nothing for you to fill in. But page 10 is very important. It goes on to talk about equal opportunity in housing. And as you can clearly see in the middle of the page, initials are required. When you turn in the listing agreement to compliance, they're going to make sure this page is included. Very, very important page. Now, a few more things I need to tell you before we conclude this segment today. I want you to be very careful let's go back to paragraph 3. Be very careful about personal property. This is a major source of disputes, complaints, and lawsuits in our industry, especially when it comes to appliances. What are built in, what are personal property? Be very clear here which appliances and other things will convey. I want to remind you that a traditional listing could become a short sale listing in the future. Or, conversely, a short sale listing could become a regular listing. How does that happen? Well, we could go out there and take a listing today where the owner is current on his mortgage. And then, after we take the listing, he can stop making those payments. That could put him in a short sale situation. Or it could also occur because of market valuation. If prices depreciate quickly, we could find that the owner is now upside down on the mortgage. Even if he is current with the payments, it could become a short sale. And if this becomes a short sale listing, it is imperative that we use something known as the short sale addendum to the listing agreement, what we call in the business the SSALA, short sale addendum to the listing agreement. That is a form in Transaction Desk. It's a form that I cover in detail in my class 6, which is my short sale class. But for today's purpose, be mindful that if this becomes a short sale at some point, we're going to need that short sale addendum so that we have proper disclosure. One more thing I want to leave you with in this segment. It is critical that when I sign a listing agreement, you get a fully effectuated copy to the seller. This could be a way for a seller to claim that we don't have a valid listing agreement if he didn't receive a copy signed by me, okay? So be very, very mindful of that. We can't do anything until we have a fully effective listing agreement. And remember what fully effective means: signed by the parties and delivered to the parties. So be careful. Always, always get a fully effective copy back to the seller. The smart way to do that is by email so that you can prove the date and time of delivery.
I would like to thank you for watching this video. I hope it was informative for you. If you are licensed with another brokerage in Southern Nevada and would like to talk with me, please text me or visit our website. See you next time.